Please, Your Lordship.
Yes, please.
Your Lordship, I pick to mention hearing item number 22 to 42, Your Lordship.
22 to
22 to 42, Your Lordship. I'm mentioning on behalf of Pendawang, Your Lordship, leading counsel for item 23, 24, and 25, Your Lordship. I repeat that the matter may be fixed again on 30th of May, Your Lordship.
you are mentioning on behalf of
Pendawang, Your Lordship, leading counsel for item 23 to 25.
Twenty-two to
42, Your Lordship.
Mr. Supamwati. Okay. The Supamwati, learned counsel, makes a mention on behalf of Mr. Benawat Wabang, the learned counsel for the petitioner in WPC 113/2020, WPC 114/2020, and WPC 2/2021. And 6 adjournment of the case on
30th May, Your Lordship.
30/5/2024. Prayer is allowed. Listed.
Lordship.
May please worship.
Yes.
I wrote hearing item 44.
Hearing item.
44, my lord.
That
This matter be adjourned today and this is after 2 weeks, my lord.
Okay.
Yes, Your Lordship.
You're the counsel for the
I'm the counsel for the private respondent, my lord.
on the prayer of Mr. Azo, learned counsel for the private respondent, listed after 2 weeks.
Your Lordship,
Fine.
there's an interim in this case.
The interim order passed earlier, so continue till the next returnable date. Okay.
Much obliged.
Please, Your Lordship.
Yes.
I beg to mention hearing item 43. I
Hmm.
pray that this matter may be listed after 2 weeks.
You're the counsel for the
Petition.
petitioner
Yes, Your Lordship.
on the prayer of Mr. So-and-so, learned counsel for the petitioner, listed after
2 weeks.
2 weeks.
Obliged.
May I please, Your Lordship?
Yes.
Lordship, item number 21, behalf of Tiba. Kindly grant this for 2 weeks, after 2 weeks.
Item 21,
21, Lordship.
Mr. So-and-so makes a mention on behalf of Mr. E. Tivapo, the learned government, and seeks adjournment of the case after 2 weeks. Prayer is allowed. Listed accordingly.
May please, Your Lordship.
Yes.
May we please to mention hearing item number 18 to 20, Your Lordship. 18 to 20,
18 to
20, Your Lordship.
yes.
Lordship, if the matter get. Your Lordship, I think there's a mistake.
Item number
18 to 20, Your Lordship.
18 to 20.
Yes, Your Lordship. If the matter can come after a week, Your Lordship.
18 to 20 on the prayer of MS Livika, the learned government advocate. Please the case after a week. Okay.
Your Lordship, I also like to mention item number 6, Your Lordship. Your Lordship, here I'm yet to file an affidavit, however, it pertains to minimum scale of pay. So Your Lordship, if 3 weeks may be granted, Your Lordship.
Item
Item 6, Your Lordship, 3 weeks may be granted, Your Lordship.
MS Livika, the learned government advocate, 6 for 3 weeks time to file affidavit in opposition. Prayer is allowed. Listed for. Okay.
Much obliged.
Yes, please.
46.
Item
Item number 46.
Ah.
Can we allow to visit matter after 2 weeks?
You have the counsel for the,
petitioner.
on the prayer of MS Spencer, learned counsel for the petitioner, listed after 2 weeks. Okay.
Yes, Lordship.
Yes,
Lordship, I beg to mention item number 2, admission
item number,
2, Lordship. Pleadings are complete, Lordship. If this matter may come up for hearing.
yes, ma'am. Okay. It is submitted by the learned counsel for the parties that pleadings are complete and therefore the matter can be listed for hearing,
Lordship.
listed for hearing in the usual course.
Please, Your Lordship.
Yes,
Your Lordship, I beg to mention item number 17, Your Lordship. I beg this matter may be passed over, Your Lordship. Here, the counsel for the petitioner is traveling, Your Lordship, from Gauhati today, Your Lordship. So, I beg this matter may be passed over for today, Your Lordship.
you are the counsel for the,
Petitioner, Your Lordship, on behalf of Sir P.P. Paul.
on the prayer of Mr. So-and-so. Pass over the matter. Pass over for the,
Lordship, there is an interim, Lordship.
the interim order passed earlier. So continue till the next returnable date.
Much obliged, Lordship.
May I please, my lord?
Yes,
My lord, I may be allowed to mention for item number 3, Lordship, on behalf of Apila Sanctum, Lordship. Lordship, I'm informed that affidavit in opposition is yet to file, and she is ready with the affidavit, but awaiting signature, Lordship. A week's time may be granted, Lordship. For
Mr. So-and-so makes a mention on behalf of Mr. Apila Sankam, learned counsel for the respondent number 5, and seeks adjournment of the case for 2 weeks to file affidavit in opposition. Prayer is allowed, listed to court.
Lordship, there is an interim.
The interim order passed earlier shall continue till the next returnable date. Okay.
obliged, Lordship.
Please, my lord. Your
Yes.
lordship, I beg to mention item number 8. Your lordship, kindly allow me 3 weeks to file my affidavit in reply.
MSV Annie Cherry,
Your Lordship, I'm for the
learned
respondents.
counsel for the petitioner, is allowed 3 weeks time to file affidavit in reply. Okay.
Please, Lordship.
Yes,
Lordship, I beg to mention item number 4.
yes.
Your Lordship, the pleadings are completed. If this matter may be listed for admission, Your Lordship.
Who's for the government? Who's for the, okay.
Yes, your lordship.
It is submitted by the learned counsel for the parties that pleadings are completed and therefore the matter can be listed for hearing. Listed for hearing in the usual course. Okay.
Lordship, there's an interim.
The interim order passed earlier shall continue till the next returnable date. Okay. Okay.
Obliged.
May I please, your lordship?
Yes.
Lordship, item number 5 and 11, it's behalf of S. Mary. She has a difficulties, so kindly
5,
This-
item number 5.
5 and 11, Lordship,
1 by 1, 5.
after 2 weeks. Lordship.
Yes, 5.
Objection, Your Lordship.
Mr. So-and-so makes a mention on behalf of MSS Murray, the learned senior government advocate, and seeks adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly. Okay. 11, same
Lordship.
order,
Yes, Lordship.
same order.
Yes, Lordship.
Okay, 11, same order. Okay.
I beg to mention item number 11.
11 mentioned after 2 weeks. Yes, next.
For motion, item number 1.
Yes,
Yeah, please, Lord. Lord, item number 1 is linked along with item number 48 and 49 in the supplementary list. This has been decked together under prayer of my learned friend on the last occasion that he wanted to club together all these 3 cases. Now, so far as the item number 1 is concerned, this is the 3rd round of litigation. Petitioner has initially filed a writ petition claiming appointment to a grade 4 post, and the representation was pending, and the prayer was to issue a direction to dispose of the representation. During the pendency of that petition, the private respondent in the other case, that is WPC number 162 of 2022. Yes,
WPC
162 of 2022. The private respondent was appointed, and it was found that later on the government came with a plea that this appointment is made pursuant to the direction of this honorable court, and the appointment was made on compassionate ground. Although there is no mention about that in that particular vacancy, in that particular office, the appointment should be made, but somehow the appointment found to be made on compassionate ground. So far as that appointment is concerned, I don't have much objection. But in the meantime, Lordship, what happened? Government vacancy arose again.
The private respondent in WPC 162/2020 is still continuing in service?
Your lordship.
Is continuing in service?
Your lordship.
Okay.
Now, during the pendency of the petition again, a controversy cropped up in the sense that the government, by way of filing affidavit, came with a contention that the agreement with the landowner is only with the PHED department, and this appointment is being sought in the Department of STIC, Industries Department.
That is
Therefore-
in the two other cases.
Yes.
Which is listed for admission.
Yes.
Yes, what about the present case?
Present case, Lordship, in the same establishment, what happened was the present private respondent, he has applied on the compassionate ground, although he is not eligible to be considered on the compassionate ground in terms of the relevant scheme. But then the government approval order was made on the basis of landowner, although he is not a landowner. So
Let us see the order.
Lordship, first, the application of the petitioner, private respondent, at page 21, annexure C. Application for appointment to the post of Chogetar under STIC Mangalamba. And then here, Lordship will find that appointment was sought on the compassionate ground. This is the application. Lordship, may kindly come to page 36.
Where is that compassionate ground in the application?
Page 36, Lordship. This is the type copy.
Page 36.
Yes,
So 21 is the application.
21 is in respect of,
This is private respondent. 21.
21 is the writ petitioner.
Okay.
36 is the application of the private respondent, Lordship. He is the immediate kin of any orphan cousin. The application was submitted on compassionate ground. Lordship will find in the last paragraph.
Page 36.
Yes. In the application, it is categorically mentioned that the application on compassionate ground last paragraph. Lordship. And then Lordship may kindly come to page 38. This is also the type copy. This is the approval of the government conveyed to the director, administrative approval. In the first line itself, Lordship will find, I am directed to refer to your letter number so and so, land owner. The word land owner is mentioned. So although the application was submitted for consideration and appointment on the basis of compassionate ground, and later on, perhaps government may have found that they cannot be covered under the compassionate appointment scheme because it is sons and daughters and the wife only, not the relatives are included. Therefore, in order to succeed the mission, they may have converted into the landowner, the government. When the application itself clearly mentions about the compassionate appointment, government has approved to make appointment on the basis of landowner, and the appointment was issued, Lordship. At page 40 is the type copy, page 40. So the very vacancy which is reflected in the appointment order, Lordship, what happened? During the pendency of the writ petition, the government has filed affidavit. And then a vacancy has been arose by filing reply to the government affidavit. We have pointed out to the respondents and this honorable court also that look, there is a vacancy in the same establishment which arose on the date of 1 Nangshimaya. So my case may be considered in against that vacancy. That was the prayer we have made. Taking advantage of availability of that vacancy, the department.
Well, what is your right to claim? What is your right to claim the post?
On the basis of landowner.
On the basis of land ownership. You are one of the landowners.
Yes. So my case are ignored from time to time, but others, anyone who comes, will be considered and appointed, in spite of the fact that there is a.
But this is that case
pending.
where you had donated the land to the industries department?
No,
PHE.
PHED department.
And PHE has actually allotted the land to the industries department.
Yes. So, Lord Chief, that was the contention of the government was that the agreement was only with the PHED and the petitioner is claiming
And
appointment.
what is the status of that case? What is the stand of the government? In that case, in those two cases which are listed for.
Yes, that is a relevant question, Lord Chief. Government has, instead of clarifying whether the agreement met with the PHED, that land, in that particular land, whether the subdivisional industries center is also located or not. That was the query from this honorable court. So PHE should come with a clear contention that yes, although the initial agreement was with the PHED, but in the same land, our office has also been set up. That should happen, the reply by the PHED. But the area of land is shown same. Yes, PHED agreement is 3 point something acres. But then PHED has come with the direct confrontation with the, to counter the petitioner's case. Although the intention of this honorable court was only to ascertain whether the initial agreement made by the PHED department includes the land occupied by industries department. There are more than 10 offices, including the additional deputy commissioner's office is situated in the same place where the initial agreement was done with the public health engineering department, Lordship. So my only prayer at this stage, without contesting his case, since it is made on a compassionate appointment, we should show compassion also. My writ petition, initial writ petition, may be disposed of with a direction to the district administration, giving in view of the policy of 5/3/2022, 2018, sorry, 5 March 2018, where there is a clause, more particularly paragraph 3, clause A, when there is a written agreement with the landowners, DC will verify and then consider the cases for appointment. If such a direction is given, the petitioner's purpose will be served, Lordship. Whether he's
That is in 48, 49.
no,
That is in admission 48, 49.
49. 48 is represented by my learned friend R. Iralu.
No, that's
And
why,
they are
that's
coming
why.
with a plea that my appointment is on compassionate ground. I need only one post, Lordships. So in 49 also there is a vacancy, but ignoring my case, the department has already appointed him. When he has.
In 48, our, this, R. Iralo's man is appointed.
Yes.
In 48.
Yes,
In
on compassionate
48.
ground.
And in this 49,
Yes.
who is appointed?
No one is appointed so far. No. That is right. In the 49, Our only prayer is, by representation is pending, let it be disposed of. So even now, if this honorable court issues a direction to the district administration to consider my case in terms of the policy, that's all.
Not to consider, to examine.
Examine and take a decision. Yes.
So that order will cover WPC 162/2022 and WPC 129/2020.
Yes.
Is it?
Yes.
No,
No, his
it's
case
not
will not
covered.
be covered.
because leadership, why I submitted before the court to list this item 48, 49, simply list with the item number 1 of today's motion list.
Correct.
Is that prior to the filing of today's motion item 1, the petitioner has been postponing the item number 48, 49 on the plea that they are going to file a petition which is similar to this one. So your lordship also may be aware, even before your lordship, the matter came up once or twice. And so that day I submitted that this may be listed along with the item number 1 of today's matter.
Case.
So the matter has been listed as a supplementary list.
Ah,
Now, in my case,
that is a 162.
162,
Ah,
the petitioner is asking for consideration of his case on the ground of notification dated
5th March 2018.
2018,
Hmm.
which is at page 42 of the writ petition.
that scheme.
Yes,
Ah,
clause 3A. Clause 3A of the notification. And this is also not applicable because 3A says where land is donated free of cost. Now, in the present case, the landowners have received compensation. That is not disputed as per records. Not disputed. Secondly, the present petitioner, he is not the landowner. He is claiming appointment on the basis of landowner on the ground that the landowners have issued a non-objection certificate for his application for the post. So he's not the landowner. Thirdly, my appointment prior to the filing of his first petition, I approached the court in WPC number 132 K of 2019 because after the death of my father, I was appointed on humanitarian ground, but on fixed pay.
this
Then-
162.
Yes.
162, the private
Yes.
respondent.
Yes. Then after continuing for some time, finally, me along with some others were terminated. Then I again applied for appointment on compassionate ground. But the matter was delayed, so I approached the court. And the court has directed for consideration of my appointment.
On compassionate.
Yes, on compassionate. So during the pendency of the first case filed by my learned friend, which is item number 49 of today's supply list, I was appointed. Then the second petition, 162, has been filed challenging that one,
Your appointment.
my appointment.
Yes.
Now, your lordship.
Just one second.
Yes.
129 is your claim for appointment on land ownership.
Correct.
When the writ petition was pending, the private respondent in 162 was appointed.
Correct.
Therefore, you had again filed the subsequent 162.
Correct.
Yes.
And subsequently, they came with a contention that this is uncompassionate appointment. If that is so, okay.
On the
but-
direction issued by the court.
Yes.
Yes.
But in the meantime, another vacancy arose. So by filing reply, we made the plea that, look, there is still another vacancy. My case may be considered against that vacancy. Taking advantage of our initiative of availability
You
of
have
the
shown the
vacancy,
way.
government has again taken the chance to
You have
make
shown the way.
appointment in the present case, so the present case.
Correct. So we issue notice in the present case, we take up all the case together.
Lordship.
Your Lordship, this may be disposed of. Because pleadings are completed, then there is no point in keeping pending this one.
This 162.
Yes. Because in fact, in this 160, the petitioner has no case.
Mr. City, whether 129 and the present, this motion matter,
Yes.
whether this will be interlinked.
Yes, very much.
There is no interlink.
No, not your case.
Yes,
Not
yes.
your case.
Yes.
But I am actually making an inquiry as to whether WPC 129 and the present petition, which is listed for motion,
Yes.
will be interlinked.
It can be linked because same office, I'm seeking appointment on the basis of landowner. And instead of considering my case, they have made fresh appointment. So government is just ignoring that even if the matter is pending in the court, we are there, we can make appointment.
So if you can establish that you are the landowner,
Yes,
then there is a question
Lordship.
to be decided.
And in order to ascertain that, the
3A.
best possible option may be 3A.
Then what about this 162? Whether you have any
162, let it
grievance
be
against-
closed, Lordship.
Yes, Your Lordship.
Ah,
Let it be closed.
we are not issuing any direction. 162.
Yes,
We are not issuing any direction invoking 3A.
the best thing would be, I may be allowed to withdraw 162 and the present writ petition may be linked along with the initial
Yes.
petition, that is item 49.
Okay. So we dispose 162.
Lordship.
Yes, Your Lordship.
162 on withdrawal, okay? This is in this 48, first in 48. First in 48, okay? Item 48. Mr. C.T. Jamia. Heard Mr. C.T. Jamia, Leonard Senior Counsel for the petitioner assisted by
I am chairman.
Mr. So-and-so, Mr. R. Iralu, Leonard Senior Government Advocate, Leonard Senior Advocate assisted by MS so-and-so, Leonard Counsel for the private respondent,
Private respondent number
and
4.
MS Livika, Leonard Government Advocate for the state respondents. Stop. Mr. C.T. Jamia, the Leonard Senior Counsel for the petitioner submits that he has instructions to withdraw the writ petition. Stop. The writ petition is allowed to be withdrawn. Is the writ petition is closed on withdrawal. Petition disposed. Okay.
Bless you.
So that ends your controversy
Your Lordship.
so far as you are concerned.
Your Lordship.
Okay, now we come to this. We issue notice, we make the appointment subject to the outcome of the writ petition.
Kindly come to page 34, Lordship.
I have seen it.
Page 34.
Of the motion matter?
Yes.
What is that? 76. What is that?
On the
34?
recommendation and note of the advisor, transport and technical education, the appointment has been made.
Mr.
No
City,
interview, nothing.
rightly or wrongly, since there is already an appointment, let us at least give a chance to the private respondent making the appointment subject to the outcome of the writ petition, or your prayer for interim will be considered on the next date fix. You select this two option. We are giving you that option.
Let it be in the returnable date. The
Consider.
interim may be considered.
Consider.
Because, yes, all the ingredients of interim.
Of course, I have
Yes.
seen. That's why I'm giving you these two
Yes,
options.
Lordship. Let me
Okay.
go for a second option.
Okay. Third, Mr. C.T. Jamia, Leonard Counsel, assisted by Leonard Senior Counsel, assisted by Mr. So-and-so, Leonard Counsel for the petitioner. The present writ petition has been filed. Impugning the letter dated 8/3/2024.
Other is 14, appointment order is 14/3/2024.
8/3/2024. Issued by the Government of Nagaland, Industries and Commerce Department. conveying the administrative approval for appointment of the respondent number 6, correct?
Yes.
To the post of MTS under Sub-District Industries Center, Mankulamba. And the notification dated. What is this notification dated?
14/3/2024.
And the
In the type
notification.
copy it is
yes,
not mentioned.
yes. And the notification dated 14/3/2024 issued by the Director of Industries and Commerce, Nagaland, Kohima, appointing the petitioner as multitasking staff,
Respondent number 6.
appointing the respondent number 6, sorry, as multitasking staff within bracket MTS under the establishment of SDIC Mankulamba. Stop. It is the case of the petitioner that the respondent number 6 is not the landowner and therefore has no right to be appointed to the said post. It is further the case of the petitioner that the respondent number 6 has no right in law to be appointed to the said post on compassionate ground. Issue notice to the respondents returnable after 4 weeks.
Let it be 3 weeks. Lord.
Why? We have one private respondent, give him, we are giving you that option, at least 4 weeks. Issue notice to the respondents returnable after 4 weeks. MS Livika, the Learned Government Advocate appears
1 to 5. Your
accepts notice on behalf of respondent number 1 to 5. Therefore, no formal notice need be issued to the state respondents. Stop. Mr. I. M. Kong. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned government advocate in the course of the day. Insofar as the respondent number 6 is concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said respondents by registered post with AD within a period of 3 days from today. Stop. The prayer for interim shall be considered on the next returnable date.
Proceeded.
This is the case. Along with, take the case. Shall we take it?
Yes, Lord.
Take the case?
129 of 2020.
Yes, along with WPC 129/2020. Okay? Yes. Okay.
For admission, item number 7.
Yeah, please, Your Lordship.
Yes.
Your Lordship, here, I'm yet to file my counter, but Your Lordship, here the petitioner is praying for release of salary for a period of 1 year, Your Lordship. And since this involves financial implication, the commissioner and secretary has not been included in this matter, Your Lordship. So the petitioner may kindly be directed to include commissioner and secretary of Directorate of Health and Welfare,
You are for the department, which department?
principal director. He's already impleted, but the commissioner and secretary of the government, Your Lordship, has not been impleted, Your Lordship. The principal director is respondent number 2.
Why have you not paid? Why have you not been paid?
My lord, the reasons are not given. My representation has not been considered.
Then what is your job?
Medical attendant, my lord.
MA,
Yes, my lord.
you're on regular appointment?
No, my lord.
Contingency, Your Lordship.
Contingency. They have extended my employment, but they have refused to pay me, my lord, for a period of 1 year.
Your Lordship, here, I've not received the parawise, but telephonically, I've been instructed that the petitioner had attained the age of superannuation in the year 2021. But the department had overlooked and given extension to the petitioner, Your Lordship. So this needs
This is the problem. See, this is the problem with the government. Where is additional AG? Any additional AG? Mr. Kyangami, this is the problem with the government. You are treating a contingency employee as a regular government employee and sending him on subordination by invoking the Retirement Act. That is wrong. That is where actually you create problem and you are not able to solve. This is I think on earlier occasion also I have actually expressed this. That a contingency employee is not a government employee. Therefore, actually the Retirement Act should not be invoked. Sometimes discuss all these things with the government. Seriously, I think. Please take up the matter with the government because this has to be discussed. I think when I was the senior additional AG, I had even written a letter to the government on this same issue. That since all this contingency employee work charge of course they have covered by a scheme, but contingency employee and all this even work charge we have stated that since they are not the regular government employees, the question of applying the Retirement Act cannot be invoked. I don't know, you are creating this problem and then you cannot wriggle out. The issue is this, the government is creating this problem and the government cannot wriggle out of this problem. That is the issue. Okay, you first file your affidavit. Let us see whether actually after that the finance would be necessary.
Your Lordship, not the finance, the Commissioner and Secretary, Your Lordship.
Commissioner and Secretary of what?
The Health and Family Welfare, Your Lordship.
Oh, that,
They have not been included, Your Lordship. The Commissioner and Secretary.
yes, Mr. You
Yes, my
have
lord.
not implemented the main party.
I overlooked, my lord.
You have forgotten.
I forgot.
Now you have realized, so take steps.
Yes, my lord. Can you
Okay.
allow me to amend my
Yes,
petition
yes,
and include the commissioner?
yes, Mr. So-and-so, learned counsel for the petitioner. Shall take steps for implementing the Commissioner and Secretary to the Government of Nagaland, Department of Health and Family Welfare, Nagaland, Kohima, correct?
Yes, Your Lordship.
Listed after 3 weeks. Okay.
Bless you.
Yes, my lord.
For admission, item number 9.
Yes,
Your
ma'am.
Lordship.
Yes.
Your Lordship, I would like to withdraw this matter. This is just a subsequent development in this matter.
With liberty to file?
Yes,
With
Your
liberty?
Lordship. Yes, Your Lordship.
MS so-and-so, the learned counsel for the petitioner submits that she has instructions to withdraw the writ petition with liberty to file afresh. Stop. Writ petition allowed to be withdrawn with liberty to file afresh. Writ petition stands disposed. Okay.
For admission, item number 10.
Yes. Hey, what's your affidavit? Counter affidavit not filed.
No file, Lordship.
Yes, so what is your prayer? Yes, what is your prayer?
No, Lordship, they have not implemented the Commissioner Secretary. Again, Lordship.
Yes, the government has not been implemented.
In that case, I may be allowed to implement the commission.
Mr. So-and-so, learned counsel for the petitioner is allowed 3 weeks' time to take steps to implement the commissioner and secretary to the Government of Nagaland, Department of Health and Family Welfare, Nagaland, Kohima. Listed after 3 weeks. Okay.
Much obliged.
For hearing, item numbers 12 to 16.
Yes, Mr. Yezo.
Hey, Mr. Lordship. On the last occasion, I have advanced my argument that a prolonged suspension is not in the interest of justice. These petitioners that have been on suspension for 4 years and a half, 4 years and 5 months now.
They are serving, let us take down the facts.
Yes.
There are 4 rate petitions.
Five.
Five. All same,
Same.
in the same department, same department.
Same order, same suspension order, same department. Now, all police constable, jail warders. they are
Jail warders.
Jail warder, and the other one is assistant jail.
Okay, let us take up 99.
Yes.
WPC 99.
99.
Ah.
The relevant page is, my lord, I just comes to relevant page, my lord.
Ah.
Page 4, paragraph. I have the short facts.
Page,
Page 4, paragraph 3. Paragraph 3, my lord. Mary,
just wait, page 4.
page 4, paragraph 3. Short facts start.
This is the facts of the case.
Yes, my lord.
Yes, please.
The big facts of it is that while the petitioner was discharging his duties as jail warden under the establishment of district jail Woka, one between, namely, when he was lodged at district jail Woka in connection with BPI PS number 15 of 19 under section IPC, died at district civil hospital Woka. In connection with the incident, submitted at Woka police station on 6/12/2019, and the case was registered by the Woka PS case number 46/19 under section 20. Based on the written FIR, the petitioner and 17 others were arrested, alleging that it was a case of procedural death. That is the 4.
Just wait.
That
Just wait, Mr. Yezo. Yes.
paragraph 4, that following the arrest, the Director General Prisons, Nagaland, Kohima had issued the suspension order number so that 28/12/2019, placing the petitioner under suspension, contemplating discipline proceeding against the delinquent official by invoking Rule 6 of the Nagaland Services within bracket discipline 1967 by law. So this is the suspension order. Well, I'll skip paragraph 5. That's only reproductions of the rules. I come to paragraph 6, my lord. Facts. That during the pendency of the trial, the additional Director General Prisons, namely Kohima, issued memorandum 17/3/2020, whereby it is proposed to hold inquiry against the petitioner under Rule 9 of the Services Discipline Appeals Rules 1967. The petitioner is also directed to submit a written statement of the defense within 10 days of the receipt memo. Paragraph 7, that the petitioner has submitted his written statement in his defense, given the detailed explanation within the stipulated time. A, that in connection with the above mentioned case, the IO of the case, after thorough investigation, has filed the charge sheet on 23/3/2022 before the district session judge Gauhati. Nine, that for the last 3 years and 5 months, the state respondent has never reviewed the suspension order as.
Just wait, just wait.
Yes, but conclude paragraph page 7. Conclusion. The normal law is that suspension order has to be reviewed once in 3 months. It is also the case of the prisoner that the suspension order should be reviewed by the competent authority after the commencement of the discipline proceeding and pass necessary order of review.
Is
without-
the disciplinary authority the competent authority? Who is the competent authority to review?
My in India case DGP.
In the present case,
Yes,
DGP,
they are all constable.
DGP, or the commandant,
Prison,
or prison,
not police. Prison.
additional
They call it,
Director General of Prisons.
yes.
So Director General of Prisons
Correct, madam.
is the competent authority.
Correct. Director General of Prisons, madam. Because they have IG prison, additional Director General prison.
So he is the competent authority to review the suspension
Very much.
order. Yes, Mr. Yazwan.
But
Yes.
so these are short facts. There is a submission that it was not reviewed at even once for the last 4 and 5 months.
For the last,
4 years and 5 months.
you're saying 3 years?
No, 4 years now, as on today, my lord, as on today. As on today, 4 years, 5 months completed. No review
Yes, we.
has been.
Four years?
5 months, as on today, madam.
Yes.
So, my lord, this is the fact. So now the other day, just to recapitulate,
Ah,
the other day I was making my argument based on the law laid down by Ambassador Ajay Kumar Chowdhury, passed in 2015.
correct.
And my lord, that same Supreme Court has been upheld by the same Supreme Court in 2018.
Yes, we will come to that, but let us see that Ajay
That is-
Kumar's case.
As far as this fact, this.
Ajay Kumar's, that day we were just
Yes,
scrolling through.
yes,
So let us see that Ajay Kumar's case, that is the basis of your case. Huh?
yes. So this Ajay Kumar has been
You have
upheld.
furnished a copy?
Yes, I'll give you the sites.
Yes, just wait. Ajay Kumar,
2015, SEC 2015.
just
SEC 2015, volume 7.
just wait. You have actually furnished the Xerox copy. Did you furnish?
Yes, in French.
Yes, just wait. Let me just if this case.
My lord, this one we did not. Other high court judgment we have. This
No, no.
Supreme Court judgment, we have just given the citation. This one.
Oh, only the citation.
So this is
So-
SEC 2015.
Yes, just wait. This is 2015, 7, SCC 291.
Yes.
Which is the para? Your line, please read.
20 and 21.
20 and 21.
Yeah, let us read this again and again by heart. Page
Just wait.
202.
Just wait.
Page
2021, correct?
Yeah, in this my
Just wait. 2015, 7, SCC 291. Okay, please read.
Yeah, my lord, before the principle laid down by the advice court is that currency of suspension order should.
You're
not-
reading which para, Mr. Zoe?
My lord, I'll read paragraph 20, my lord.
You're reading para 20.
20.
Okay.
Three. After judicial. The Code of Criminal Procedure. Which has decided the power of the magistrate authorized detention of an accused person where there is punishable in that imprisonment for life or imprisonment for a term of not less than 10 years. And where it is still released to any other person or from the application of the legal bank influence and also of the constitutional bank influence. We are starting to extrapolate the quintessence of the proviso to section 172 of CRPC 1973 to moderate suspension orders in cases of departmental/district inquiries also. It seems to us that if Parliament considered it necessary that a person be released from incarceration after the expiry of 90 days, even though accused of commission of the most heinous crimes, for sure, suspension should not be continued after the expiry of the similar period, especially when a memorandum of charges/charge sheet has not been served on the suspended person. It is true that the proviso to suspend section 167 postulates personal freedom, but respect and preservation of human dignity, as well as the right of to a speedy trial, should also be placed on the same pedestal.
Just,
21.
yes, just wait. Now 2020, let us come.
Yes.
Especially when a memorandum of charge sheet has not been served on the suspended of person.
Yes.
So the forgery. Suspension should not be continued after the expiry of a similar period, especially when memorandum of charge sheet has not, in the present case, memorandum of charge sheet submitted.
After 90 days.
No, but it has been submitted now.
Submitted.
Just wait, okay?
Yes, ma'am.
Let me be very clear on this. This memorandum of charges
Yes. In the present case, fine.
has been submitted.
Yes.
So para 20 is of little importance.
Yes.
Correct?
Yes.
Now next para 21.
Next para.
Yes.
Para 21. We therefore direct that the currency of the suspension order should not extend beyond 3 months if, the word if, within this period, the memorandum of charges slash charge sheet is not served on the delinquent official employees. If the memorandum of charges slash charge sheet is served.
Yes,
is
now
served,
this is relevant.
that is relevant.
Is served.
Is served.
Ah,
A reason order must be passed for the extension of the suspension. That is the only issue
correct.
which they have not done.
Okay, just para 21. Just wait, okay.
If the charge sheet is served or memorandum is served, a reason order must be passed for the extension of the suspension.
So this para 21 is relevant.
My lord, just for
If the memorandum of charge sheet is served, a reason order must be passed for the extension of suspension.
so
Any duration laid, when the reason order should be
very
passed?
much after every 3 months.
Where is that?
Periodical review.
Periodical review, where is that?
After every 3 months.
Where is that 3 months? Huh?
My lord, lordship will see now the principle. It is written here. But
We
before
therefore
that-
direct that the currency of suspension should not extend beyond 3 months. If within this period, the memorandum of charges sheet is not served on the delinquent officer.
So that is
If the memorandum of charge sheet is served, a reason order must be passed for the extension.
of the 3 months, so periodical 3 months, meaning the principle has been followed, the CRPC laid down under 167, CRPC section 67. In the case of criminal case, in case of criminal case, madam, in case of, lordship will appreciate here, in criminal case, I come the criminal case, in case of criminal case, supposing a serious offense has been committed by me, so the mandatory period for the IO to file charge sheet is 90 days, as per section 167 CRPC. But that was not there prior to 1973 amendment, CRPC amendment, not there. Now with the amendment of CRPC in 1973, the mandatory period for the IO to file charge sheet is 90 days in case of serious offense.
Yes.
If it is
Less serious, 60
then
days.
60 days. So this Supreme Court had no. If that is the principle laid on the CRPC, why not in civil law?
Same analogy can
Same
apply.
Why not? So when the objective laid of the parliament is on that in CRPC, why not suspension in civil law? That is the principle as adopted. Now in the present case, charge sheet was not out, charge sheet was filed after 90 days, not out, but served. I agree.
Lordship, one
Now-
correction. So it was served within 30 days, 90 days. Lordship.
Okay, it's all right.
That is, my friend is talking about memorandum. I mean charge sheet.
Memorandum of charges.
I'll
No,
show
both,
my-
both.
Memorandum of charges.
Memorandum of charges as well as charge sheet.
The articles of charge.
Simple as this. These 18 of them got got default bail for the I open no file charge sheet within 90 days. So default bail was otherwise it's alleged murder case. So after the expiry 100 days, even after 100 days, I open no file charge sheet. So we got default bail. My lord, here the principle laid down by the Supreme Court in Ajay Kumar's case is this, as I have narrated. Prior to 1973 amendment of CRPC, no this principle was discussed. what I have observed was. Now, after 1973 amendment, 167 was inserted. So now that has become mandatory in the case of criminal law, in respect of criminal law, for the IO to file charge sheet in 19, otherwise it will be continuous torture. So Parliament has come to a finding that no, this is wrong. So even in serious case, 90 days is enough for the IO to find out the truth. If they cannot, there may not be any substance. So grant him bail. So that principle has been laid down in the criminal law. So after going through this Supreme Court has had no. There should be a comparison and there should be equity, even in civil law. So therefore, in this Ajay Kumar's case, same principle as narrated in 2020, section paragraph 20, Supreme Court held that look, if the mandatory period of 90 days is mandatory for the IO to file charge sheet in case of civil offense, why not in civil law also? Now, therefore, in the case of criminal case, IO is expected to file within 3 months with 90 days. If not filed, bail granted, default bail. So, similar paragraph 21, Supreme Court says, we therefore direct the currency of suspension order should not extend beyond 3 months if within this period the memorandum of charges or charge sheet is not served on the delinquent official or employee. If that memorandum of charges or charge sheet is served, a reason order must be passed for the extension of the suspension order.
Suspension order before the expiry of every 30 days.
Yes, periodical. Every that is the law now. So now after that,
So your submission is that the order of suspension must be reviewed before the expiry of every 30 days.
very much. So that there will be continuity. So that the suspension order will survive. Now, my lord, it said that the judgment has been discussed subsequent Supreme Court, SEC 2018. SEC 2018. Eleven pages.
SCC 2018-17, just wait, 2018. Six, seven, seven, relevant para.
The relevant paragraph is 24 to 27. To 27, right?
Yes, please. Yes, please.
The heading itself is called suspension.
Yes.
Paragraph 24. The first respondent was placed under deemed suspension under rules of all India services for being in custody for a period of more than 48 hours. Periodic reviews were conducted for his convenience under suspension. The recommendation of the review committee did not favor his reinstatement, due to which he is still under suspension. Mr. P. Chidambaram, learned senior counsel appearing for the first respondent, fearing submitted that
we can proceed.
We can proceed on the basis that the criminal trial is pending. There cannot be any dispute regarding the power or jurisdiction of the state government for continuing the first respondent on the suspension pending criminal trial. There is no doubt that the allegations made against the first respondent are serious in nature. However, the point is, this is the relevant principle. However, the point is whether the continuous suspension of the first respondent for a prolonged period is specified. In this case, there was 6 years suspension. In our case, 4 years and 5 months. The first respondent has been under suspension for more than 6 years. while releasing the first respondent on bail, liberty was given to the investigating agency to approach the court in case he indulged in tampering with the evidence. Admittedly, no complaint is made by CBI in this regard. Even now, the appellant has no case that there is any specific instance of any attempt by the first respondent to tamper with evidence. In the minutes of the paragraph 26.
26 years.
27.
You have not read 26?
Okay. In the minutes of the review committee meeting held on 27/6/2016, it was mentioned that the first respondent is capable of exerting pressure and influencing the witnesses, and there is very likelihood of the first respondent losing office if reinstated as Inspector General of Police. Only on the basis of the minutes of the review committee meeting, the principal secretary, Home, SC, department ordered extension of the period of suspension for a further period of 180 days beyond 9/7/2016 by Commercial Issue. 27. This court in Ajay Kumar Chaudhary versus Union of India has frowned upon the practice of protected suspension and held that suspension must necessarily be for a short duration. On the basis of the material report, we are convinced that no useful purpose would be served by continuing the first respondent under suspension any longer, and that his reinstatement would not be a threat to a fair trial. We reiterate the observation of the High Court that the appellant state has the liberty to appoint the first respondent in a non-sensitive case. So therefore, in the same Ajay Kumar's case, prolonged suspension was not appreciated. So therefore, the same High Court in this case Supreme Court has upheld the judgment of Ajay Kumar's case. Or you have seen in paragraph 24, periodic reviews, even in this case. Periodically, it has been reviewed. After every three months, periodical review should be done.
Yes, where is the judgment of our own High Court division bench?
This is our High Court is 2009, Supreme Court 18, this is 19 now. Division bench. JLT 2019, volume 5.
We have given photocopies.
No. JLT 2019, volume 5.
Yes, sir. Triple four. So relevant para?
Relevant paragraph is just comes to 12 and 17, 18. 12, 17, 18. 12.
12.
17. May I read my report?
Yes, please. Yes.
And the aforesaid observations those who show that the application made therein are on the subject matter of suspension in general and the same are not restricted to the provisions of CCS rules 5 in particular. In fact, it is as clear from the above extracts, including paragraph 21 of Ajay Kumar Chaudhary Sutra, that an order of suspension should not extend beyond 3 months if within that period of 3 months a memorandum of charges or charge sheet is not served on the employee under suspension. Further, it is clear from the above judgment that if a memorandum of charges or charge sheet is served, this order must be passed for extension of the suspension. In laying down the said proposition, the Honorable Supreme Court has referred to the provisions of section 167 Code of Criminal Procedure 1973. Thus, it is made clear that an employee's initial period of suspension can be for a period of 3 months from the date of suspension, and if within that period the memorandum of charges slash charge sheet is not served on the employee, the order of suspension loses its force and in case within that period of 3 months, the memorandum of charges slash charge sheet has been served and the competent authority is of the opinion that the period of suspension should be continued beyond the period of 3 months, then also a written order must be passed for extension of the period of suspension. Paragraph 17. The respondent were placed on the suspension on 6/10/2017. If it is assumed to be on the purported ground under Rule 6 of 1976 rules, when the appropriate authority decided to grant execution sanction in the respect of 5 numbers of government employees, including the respondents herein, as it transpired, the charge sheet under section 173 CRPC was submitted by the investigative agency before the direct court in 2012-17. In view of the submission of the charge sheet in particular case number 24, it prima facie appears that all the necessary material have been collected by the agency to prosecute the array carrying including the respondents, to prosecute them under the appropriate offenses. There is no whisper in the affidavit in opposition filed by the appellant. Here, appellant statement. Appellant herein as the respondent in the writ petition to the fact that there was any attempt on the part of the respondent to interfere in the process of collection for dividend or to tamper with the evidence or to influence the witnesses in any manner. There is no indication in the charge sheet that any further investigation is necessary to unearth any further evidence. In view of the aforesaid discussion, we are of the considered view that the latter single judge is not unjustified in reaching the ultimate conclusion that the period of suspension of the respondent in absence of any reason order passed in review cannot be prolonged, and therefore it is justified in setting aside the order of suspension that is 6/10/17 in respect of both the respondent. Consequently, we do not find any merit in the appeals, and accordingly the same are dismissed. There shall be options. So this is the appeal and appeal of dismissed. Because in this case, the London single judge had passed the order setting aside the suspension for not conducting verifiable review with reasons. My lord, I have another judgment of this High Court. Worship, I have read out hundreds of judgments have been passed by the same High Court, by the on Gauhati High Court. My lord, last time I have given judgment.
What is the citation?
I have provided section these. OPOs are given. Because this is 2024 case now. That will come back.
What is the citation?
Citation is Sapina.
Sabina Langthasa.
Yes. This was no paragraph is written. It's not
Just wait, this is,
on the same principle, my lord.
this is reported.
This is just recent 2024. My lord. There are several judgment passed in 2024 also, apart from this. That is based on Ajay Kumar Chaudhary's case.
Excuse me for 3 minutes.
That are wrong.
Yes, Mr. Zoll.
My lord, the relevant page will be page 4. Page 4. Page 4. Having heard.
Yes.
Page 4.
Having heard.
The having
Okay.
having heard learned counsel for the parties and upon careful perusal of this petition. This four is of the view that time and again, all over Supreme Court as well as this court has passed several orders interfering with the suspension order where there is a failure on the part of the country to review the continuance of the suspension as mandated by law. This law has been clearly laid down by the Atas Kumar before 15. And this judgment has been followed by the honorable benches as well as several other courts, coordinate bench of this court in several judgments. It is to be noted hearing that the question as to whether the discipline authority would be entitled to take an under prolonged suspension without reviewing the order came up for the constitution before the honorable Supreme Court in the case of the findings of the appellate court in paragraph 20 and 21 of the same decision relevant to the facts of the case are therefore excerpted below. Let me put it, my lord, is because you have that. And also come to page 6, my lord. Page 6. The ratio laid down, my lord. The ratio laid down in Ajay Kumar Chaudhary Supra has been applied by the honorable bench of this court in so and so versus so and so reported in 2019, 5 GLP so and so, and the petition number so and so, wherein it was held that the principle laid down in Ajay Kumar Chaudhary Supra will be applicable in cases of Assam Police, Assam Services Discipline. Same view was rendered by another division bench of this court instead of Assam versus Ajit Sonowan. In its judgment, 3 coordinate bench have also applied this ratio in Prophet Assam and others in the and Tapan Das versus Assam by its judgment and ordered 1611 in view of such authoritative finding of the appellate court and which law is followed by the division bench and other branches of this court. The authorities are duty bound in law to comply with the principle laid down by the appellate court in Ajay Kumar. Well, this much I like. Then on prolonged judgment, prolonged suspension. This is GLR 1990. GLR 1990, volume 1, page 276.
This is 1990.
1990. On prolonged suspension, no review was discussed here. On prolonged suspension, whether it is justified to keep a person under prolonged suspension.
Which
This
para?
was-
Like DB.
Paragraph 5 and 6, madam. Short. Paragraph 5 and 6, madam.
Yes, please. Yes.
Without entering into that controversy at this stage, we think that prolonged suspension for more than 3 years of the petitioner from service without any further action having been taken in the matter was neither proper nor justified. 6. Suspension from service is a very serious matter and should be as minimum period as may only to be necessary. A prolonged suspension without any justifiable cause is not only wastage of human resources, but also of material resources of the organization, which has to pay the subsistence allowance, etc., without any return, we find absolutely no reason to continue the suspension of the petition. For long, now in this case, 3 years, in our case, 4 years and 5 months. My lord, these are the judgment. Like I said, my lord, this High Court has passed at least more than 10 judgment, even this year itself, based on Ajay Kumar's case. Now, Lordship, I'll just the Supreme Court judgment which my learned friend had referred last time. Just yeah, 1964.
Wait.
The judgment my learned friend has shown.
Just wait.
Yeah, 1964.
AIR
1964.
1962. Kem Chan.
64. 1964.
Parties?
Yeah, 1964. His name R.P. Kapoor versus Winner of India.
Just wait. R.P. Kapoor.
Yes.
This is reported in Manupatra. This is reported in AIR.
1964.
AIR 1964.
Volume 51.
AIR 1964, volume 51.
SC. Supreme Court.
SC. Look at this book is available here. AIR 1964, volume 51, SC.
I just want to take Lordship's attention to para 7, just to show what issue was before this law.
Just wait.
What
Just
was the
wait.
issue before this law?
You please call that book. Please call that book. Because I think Manupatra and AIR, I think the paragraphs will be different.
Sometime paragraphs.
So I want to read from that AIR. AIR 1964, volume 51, SC. This is page?
Page 787.
Page 787.
Yes.
Got it? Okay. Okay, just read. Okay.
7.
AIR 1964, 51, SC 787. Yes, which
Paragraph 7.
let us see. We have that same paragraph here.
I just only one sentence.
Just wait. I just want to see whether we have the same paragraph. Is it the High Court dismissed the petition? Starting from? By your para 7, the High Court dismissed the petition. That is the difference.
Just below that. Next paragraph.
What was that?
Next paragraph.
The only question?
Yes. The only question. Actually, in this book, paragraph. Lordship is right sometimes, their paragraphs are slightly changed.
What is this? Paragraph 7 means the facts of the case.
The question of law involved in this case. The question of law involved in this case.
Yes.
And just only one sentence.
Yes, please.
The only question that has been debated before us is with respect to suspension whether as a punishment or otherwise of a member of one of the Secretary of State Services in this case, the Indian Civil Service members of members of which have become members of the Indian Civil Service under the recruitment rules, and it is only this question that falls to be determined in the. My lord, here, my learned friend is saying, this is of 5 judges of Supreme Court. And this judgment was not referred in Ajay Kumar's case. This is what my learned friend is making submission there. I said this is not relevant. This is not required, number one, because the only question before this court in this case is to determine whether the suspension should be treated as punitive or otherwise. Here,
Just read suspension, whether as a punishment or otherwise.
Yes, only
or
that much.
Otherwise, of a member of.
Lordship, the only question that has been debated before us is with respect to the suspension, whether as a punishment or otherwise. Suspension can be treated as punitive or not. Order 7. Next. My lord, in the facts is what happened was this.
No, just wait.
Yes, ma'am.
You are reading R.P. Kapoor, na? R.P. Kapoor.
Very much. Order 7.
Okay, just wait. Para 7. The only question, let us read once again.
Yes.
From this book.
The only question that has been debated before us is with respect to suspension, whether as a punishment or otherwise, of a member of one of the Secretary of State Services, in this case, the Indian Civil Services, members of which have become members of the Indian Civil Service under the recruitment rules, and it is only this question that falls to be determined in the. My lord, before independence, this secretary, before independence, he was recruited during British time, before 1747. Then after independence, he had been inducted as Indian Administrative Service. But that time the question, he was placed under suspension. So the question arose before the Supreme 5 judges, whether his suspension should fall under old law before independence or post-independent one. Most important question, whether suspension can be treated as punishment, punitive or not. That was the only issue debated before 5 judges. The facts are narrated, no doubt. So therefore, my submission before this court is, while my learned friend says, in Ajay Kumar's case, my friend say that these 5 judges' judgment has not been referred.
Yes.
In this case, the principle governing talking about periodical review was not discussed.
No.
So therefore, why this should be referred? So therefore, rightly in Ajay Kumar's case, Supreme Court has not referred this matter because in this case, the issue before this court is only to decide whether suspension should be treated as punishment or not. They are not talking in this case. It is not talking about periodical review. Lordship will see. My friend also can show with this court whether there is any paragraph discussed in this Kapoor's case regarding the suspension, the periodical review of suspension. Because why that was not discussed, why that is not the issue before the 5 judges, what is the necessity for the Supreme Court in 2015 refer this matter? Why these two are not connected legally?
So here in this, RP Kapoor's case, so no discussion.
Nothing.
This was made on the
Yeah.
review of periodical
Nothing,
suspension.
nothing. Therefore, why it should be deferred? That is my submission. If it is discussed, and if it is discussed, whether the Supreme Court something will defer or compel, that should be discussed.
Of course, yes.
But it is not discussed, so therefore, why should be relied? That is my submission.
Correct.
Then number two, my lord, why should not be real number two is because 1964, in 1964, CRPC was not amended. CRPC was amended only in 1973. So therefore, in 2015, when in Ajay Kumar's case, when Supreme Court take up periodical review, it came to the minds of the Supreme Court, no, there should be equity. If 90 days is mandatory in criminal law, then the same principle should be applied in civil law, because that is the objective laid down by the parliament. So that's how Supreme Court had discussed 2015 in Ajay Kumar's case about periodical review. So this is the difference between these two cases, Mike. Yes. So therefore, in my humble submission, yes, I respect my learned friend's submission. He'll satisfy that point, but there's no reason why we should be relying. And for not relying this case, for not relying this judgment, whether the reasonable court can hold that the judgment passed by the Supreme Court in Ajay Kumar's case is bad in law, actually cannot. This court cannot give any finding between Ajay Kumar's case and this case. Why the issue is different?
There is no comparison.
No comparison. So therefore, how can all of us insist the court to give any finding which one is right? Why there is no comparison? Why there is nothing discussed about periodical review of this case? Now another judgment my other friend has referred was High Court, like full bench High Court.
Madras.
Madras. My lord, worship was very well. The Madras High Court judgment will not bind on this court. Madras High Court judgment cannot overrule Ajay Kumar's case. Even otherwise, in Madras High Court case, my lord,
Any citation on this Madras?
I did not, I thought it's not necessary also, because lordship, as I have made my submission, even in 2018, the Supreme Court has upheld the Ajay Kumar's case. Ajay Kumar's case. So, my lord, I don't know, it's in my with my limited knowledge. High Court cannot review or overrule the judgment of this. Even if they express the different opinion, even if their opinions differ, individually anybody can differ there. Like Kapil through conversation in internet now. And like I have gone through the late Fali Nariman's interview. He said the abrogation of Jammu Kashmir 370 absolutely. He said this is bad in law. He used the word bad in law. Personal view, but that does not bind the Supreme Court. Present Chief Justice Chandrachud saying when Rajan, former Chief Justice Rajan Gogoi in Parliament said that this is their view. Chief Justice President, no, that is personal view.
Personal view.
Personal view. So that has no binding on the court. So therefore, whatever view expressed by the Madras High Court.
So which is that para Madras High Court?
My lord, my lord friend will rely
Okay.
because I don't want to hijack his citation. Let him satisfy the court. That is my humble submission.
No, this court would also like to know how this Madras High Court judgment is not relevant
It's not
from you.
Yeah, not relevant in because my lord, simple as this, that judicial tradition, my lord. Supposing division bench of this high court has laid down a law, then as going by the judicial tradition, the land a single judge cannot overrule unless it is referred to a larger bench. That is the judicial tradition, my lord. And that is the legal position, my lord. So therefore, in my humble submission, the observation made by the Madras High Court cannot be considered as that it has overruled Ajay Kumar's case. That is my humble submission.
Of course, obviously, that is a video.
But, so therefore, if this honorable court pass any judgment different the principle level Ajay Kumar's and 18, that will be a new judgment, my lord. That will be new.
It will be a Herculean task.
My lord. So therefore, today in the present case, in my humble submission, the suspension order dated 28/12/2019 passed by the Director General of Prison is bad in law for not.
Which is that order? Let us see, as per your annexure,
Yes.
which is that order? Suspension order?
My lord. My lord, typing copy is page 14. My.
Page 14.
Original is 13, but that is not readable.
Page 14.
Yes, ma'am.
This is the suspension order.
Correct. Initial suspension order. Page 14. And it should be my lord. The suspension order issued by the Director General Prison is bad in law for not reviewing the as it has as that was done. So therefore, the interference is number 4 has the power to interfere with the suspension. In all 5 writ petitions, suspension order same official, same authority, same order.
This petitioners in all the writ petitions, they were holding the same post.
One is assistant jailer. The last petitioner, writ petition number 103 is assistant jailer.
Yes, see. And the rest, warder.
Warder, equally warder.
Warder.
Constable, senior constable.
And the writ petition, which is that assistant?
WPC 103 is assistant jailer.
WPC
103. 103.
103 of 2023 is assistant jailer.
Assistant. Head warder.
Head warder.
Head jail warder.
Achha. And the rest
Warder.
in WPC
101.
101/2023.
Head warder.
Rest, warder, warder.
thought the other day, my learned friend has fairly submitted at the bar that though the suspension order say that in contemplation of employment proceeding, till today at the bar he had mentioned, till today no proceeding has been initiated after 4 years and 5 months. So therefore, keeping them under suspension for 4 years to 5 years will not serve any good purpose. Rather, it is causing a loss to the government exchequer money. Without utilizing the service of these 5 petitioners.
Yes, Mr. Kiangami, is it not beneficial for you to reinstate them, use their service?
Lordship, coming to questions of law,
Ah,
I will just supplement my learned senior friend.
you will supplement,
perhaps.
not, you will not object.
And point out where he has missed.
Ah, okay, let us see whether,
This will be all about borrowing from here and there, Lordship.
Ah.
This is a second exercise.
now the facts are clear. Facts are clear, come, let us come to the law.
Yes. Now,
What is your point on law?
Lordship, Ajay Kumar Chaudhary case, Lordship, paragraph 21. My learned senior friends has read the first part of the paragraph. I'll try to cover a second and the 22nd paragraph.
Yes, now let us come to
Ajay Kumar Chaudhary case, Lordship.
Rajay Kumar's case, just wait. Rajay Kumar is 2015, 2015, 29. Yes.
The second sentence, 21.
Para?
21,
Para 21.
yes, second sentence.
Okay. Para 21.
Yes.
Okay.
As in the case in hand, the government is free to transfer the person concerned to any department in any of its office within or outside the state so as to sever any local or personal contact that he may have and which he may misuse for obstructing the investigation against him. The government may also prohibit him from contacting any person or handling records and documents till the stage of his having to prepare his defense. We think this will adequately safeguard the universally recognized principle of human dignity and the right to a speedy trial, and should also preserve the interest of the government in the prosecution. We recognize that the previous constitution bench have been reluctant to quash proceeding on the grounds of delay and to set time limits to their duration. However, the imposition of a limit on the period of suspension has not been discussed in prior case and will not be contrary to the interest of justice. I think that part will be relevant for
Yes. What do you mean to say?
Lordship. But before dwelling on that, instead of coming back again, I want to take my lordship paragraph 22.
No, para 21, you explain what is this? I have understood. What is your understanding of para 21? You are banking on para 21.
Yes.
I have understood this para.
Yes.
What is your understanding? Let us
So,
differentiate.
My learned friend has submitted, or even this judgment has said that this constitution that has not discussed.
However, the imposition of a limit on the period of suspension has not been discussed in prior case law. and would not be contrary to the interests of justice. What does it mean? It has not been discussed before. So even if there is a discussion now, it would not be contrary to law. That's all.
No, that is what the judgment says. Lordship.
That is what the judgment says, para
Yes.
21.
So now, what?
What is that something else? Let us see, Ajay Kumar.
Paragraph 10, Lordship.
Which para?
Paragraph 10, RP Kapoor, Lordship. RP Kapoor case, 1964. Here, it says why it is necessary, Lordship.
You have taken me to Ajay Kumar's case, but you have not been able to substantiate.
Lordship, I'm going to point out from the five judgments, Lordship. Or Lordship, to make it more, from the observation made by the Madras High Court. Here, they have systematically point out everything, Lordship, instead of going here and there, Lordship.
But let us see our Supreme Court, Madras High Court later
Yes,
on.
no,
Only
no,
if it is relevant, I'll tell you to rely.
Oh, only I'll take
You tell us from this RP Kapoor's case.
Lordship, everything. I'll just how they have discussed the case in our in Madras case. I'll going to take my Lordship 2, 3, maybe 4 paragraph, 2, 3 paragraph.
No, what is that relevancy in RP Kapoor's case? Tell me.
It is discussed here, Lordship.
It is discussed there, but let first take me to RP Kapoor's case. You are leaving aside Supreme Court's constitutional based judgment, and then you want to take me to Madras High Court.
Lordship, I'm coming to that. Lordship.
I want you to
What
satisfy
I'm
me with
saying
this
is-
5-court judge.
Lordship, what I'm trying to say is a larger best has already discussed this.
What is the discussion? That's why I'm telling you. Take me.
Page Manupatra. This Manupatra, RP Kapoor case.
Yeah, which okay.
Paragraph 10. I've also submitted it, my lords. Then I think it should be. Most probably paragraph 11 there, Lordship.
Which is that para starting with the general principle. What does that Manupatra start with?
Another argument, Lordship. I think it's paragraph 11 there.
No, paragraph 11 is this is R.K. Kapoor. The general principle is therefore.
Then paragraph 10, Lordship.
Another argument.
Yes.
Para 9. This is para 9.
Yes.
Para 9. Okay. Another argument.
Yes.
Read.
Another argument is urged on behalf of the respondent that suspension pending a department inquiry or pending a criminal proceeding cannot be said to be a disciplinary matter at all, and therefore the protection of Article 300(1) doesn't extend to such suspension. We cannot accept this argument. The words disciplinary matters with which we are concerned appear in the constitutional provision and must be given their widest meaning consistent with what disciplinary matters may reasonably include. Suspension is of two kinds, namely as a punishment or as an interim measure pending a departmental inquiry or pending a criminal proceeding. We shall deal with this aspects of suspension in detail later. So far as suspension as a punishment is concerned, it is considered that it is a disciplinary matter. The dispute is only as to suspension pending and departmental inquiry or pending a criminal proceedings. There can, in our opinion, be no doubt that suspension of this kind also must be comprised with the words disciplinary matters as is used in Article 314. Take the case of suspension pending and departmental inquiry. The purpose of such suspension is generally to facilitate a departmental inquiry and to ensure that while such inquiry is going on, it may relate to serious lapses on the part of a public servant. He is not in a position to misuse his authority in the same way in which he might have done so in the inquiry. In such a case, a suspension pending a departmental inquiry cannot be but a matter intimately related to disciplinary matters. Now, Lordship, the next sentences are important, Lordship. Take against the case where suspension is pending criminal proceedings. The usual ground for suspension pending a criminal proceeding is that the charge is connected with his position as a government servant or is likely to embarrass him in the discharge of his duty or involve moral turpitude. In such a case, a public servant may be suspended pending investigation, inquiry, or trial relating to a criminal charge. Such suspension also, in our opinion, is clearly related to disciplinary matters. If the trial of the criminal charge results in conviction, disciplinary proceedings are bound to follow against public servant so convicted. Even in case of acquittal, proceeding may follow where the acquittal other than honorable. Next paragraph. The usual practice is that where a public servant is being tried on a criminal charge, the government postpones holding a departmental inquiry and awaits the result of the criminal trials, and these departmental proceedings follow on the result of the criminal. Therefore, suspension during investigation, inquiry, or trial relating to a criminal charge is also, in our opinion, ultimately related to disciplinary matters. Lordship. So what I'm trying to say is, though not as lengthy as, no, very lengthy, here it was already discussed. That is right or wrong. That is my humble submission, Lordship.
Assuming that the criminal trial is pending, even in the present case, a criminal trial is pending. What difficulty is there for the government? What difficulty is there for the department to review the periodical suspension? Assuming, even assuming, okay, let us take into fact that the departmental inquiry is pending against the petitioner. Now, what difficulty is there for the department to review the periodical suspension? That is what the Ajay Kumar case says. You are right, we are not disputing this. But in your Kapoor's case, the periodical review of suspension has not been discussed. That is the issue. And that is actually a new law laid down. Periodical review of suspension is a law laid down by the Honorable Supreme Court in Ajay Kumar's case.
Yes. Lordship, what Lordship here in Ajay Kumar part 2021 said that he should be transferred out to some other places.
No. That is very normal. That is very normal. That is what the Supreme Court says. If a criminal departmental inquiry is pending against a particular person who is under suspension, in order so that he does not tamper with the evidence, he should be transferred out.
Yes.
That is what it says.
But
there is no connection with the periodical review. Okay, you submit. I'm listening.
So you're
Mr. Kevi,
yes, Lordship.
Why don't you reinstate them? Use their service. Instead of just keeping them under suspension, providing them with subsistence allowance, not utilizing the service. That is what the Supreme Court has also said.
Lordship of the record, I'm not going to advise against your judgment, but at least it is my duty to bring to the notice of the court. What other courts is discussing
after your reference to Kapoor's case, I find that it has absolutely no connection with Ajay Kumar's case. Okay. That is what I find. Okay. And Mr. Ezo is right, that it has no connection between Kapoor's case. If Kapoor's case had any connection,
yes,
we would have actually given the opinion that Ajay Kumar's case was passed per inquiry. Or what was that?
Nothing is discussed. Yes, not in our High Court, Honorable High Court. We are not discussing. We are solely behind the laws or whatever is laid down in the by the Ajay Kumar's case. But that's where.
And see, Ajay Kumar's case, if suppose in this Kapoor's case, which is by constitutional bench, yes, 5 judge, I think Ajay Kumar's case, if the periodical review of suspension was discussed in this Kapoor's case, then definitely Ajay Kumar's case would not have overlooked this important judgment.
But that wasn't discussed in the just.
No, it is not discussed. Periodical review of judgment, any paragraph you show will give importance to that. That is periodical review of a suspension. If it is discussed in Kapoor's case, you please show this court, we will give importance to your submission. And if we can read somewhere in the paragraph about the Honorable Constitutional Bench discussing the periodical review of suspension, then in that case, this Ajay Kumar's case would be per inquiry. But as rightly pointed out by Mr. Ezo, nothing is discussed in this Kapoor's case. Maybe you want to stretch Kapoor's case too far.
No, but other courts have been discussing, though that is not binding on us, Rashid. Discussing, and they say that
When
generally
see,
says that-
Mr. Tiangami, simple as that, when Kapoor's case has not discussed, where is the question of the other high courts discussing this issue in violation of the law laid down by the Honorable Supreme Court?
They also say
There is no question of but so.
all this, Rashid.
Just because Madras High Court has discussed something which is not in tandem with the law laid down by Ajay Kumar's case. How do we accept that? And more so when our Honorable High Court, Division Bench as well as Coordinate Bench, has already adopted Ajay Kumar's case.
In Supreme Court, 2018.
That was also discussed by the Honorable High Court, Madras High Court.
Well, I think you have not convinced this court.
Of course, I mean, not.
You have not. So, okay, let us not discourage you. Let us refer to your Madras High Court.
Page, coming to some of the
Yes,
observation made by the High Court.
this is not reported.
I downloaded from the website. So the Kanan, the Commission of Municipal Administration, to others.
This is okay. This is by a full bench.
Yes.
Let us see.
Four paragraph.
Yes, which are the paragraphs?
18, paragraph 18.
Paragraph
18. It's page 23.
Paragraph 16, 17. Yes.
Two sentences I'll read. It needs to be clarified that the provisions of the Code of Criminal Procedure 1973 would have no application to the service jurisprudence. And accordingly, the judgment of the apex court in Ajay Kumar Supra needs to be considered for its applications. So in such context, the division bench of this court in Arik Nar, Anna Sugar Mills, in the Supra held that the law lays down by the apex court in the case of Ajay Kumar Supra does not lay down any absolute proposition that order of suspension cannot be extended beyond 3 months. Then allow me to take my lord to page paragraph.
Okay, here again, pause for a moment. Here, Madras High Court says that the law laid down by the apex court in Ajay Kumar's case does not lay down any absolute proposition that the order of suspension can never be extended beyond 3 months. Our High Court has stated that the proposition laid down by the Honorable Apex Court in Ajay Kumar's case is to be followed. And thereby our High Court is also against the fact that suspending an officer or an employee of the government without any periodical review is against the law laid down in Ajay Kumar's case. Which to follow? Now, let us see. You just tell me, which is to be followed? The law laid down by the Madras High Court, which says that Ajay Kumar case does not lay down any absolute law that no order of suspension can be passed after 3 months, or the law laid down by our Honorable High Court in tandem with Ajay Kumar's case.
Lordship, if our court is convinced with the interpretation rendered in view of the RP Kapoor case.
If we have a look, if we just have a glance, maybe if I'm not wrong, this is going against Ajay Kumar's decision.
Yes, it is, Lordship.
It is. You are also in agreement.
Yes, but there the strength relies on Khemchand, that is Supreme Court, and not 5 bench, then RP Kapoor case. So whether accept it or reject it, Lordship, paragraph 22, 23, 24, not very long. If I not all they've completed their.
Para Kapoor's case, I am totally, that judgment is out. Kapoor's case, it has no relevance. Now that's why we are now referring to Madras case.
Yes. Paragraph 22. Page 28.
Paragraph
22.
22.
Moreover, there are a series of Constitution Bench judgments pertaining to a challenge to order of suspension, which were not placed for consideration before the Apex Court in Ajay Kumar Chaudhary Supra. For instance, in Khemchand, Union of India, there is also a 5 judges bench of the Apex Court held as under. Nobody can seriously doubt the importance and necessity of disciplinary action being taken against government servants for inefficiency, dishonesty, or other suitable reasons. Such action is certainly against the immediate interests of the government servants concerned, but is absolutely necessary in the interest of the general public for serving those interests that the government machinery exists and functions. Suspension of a government servant pending and inquiry is a necessary part of the procedure for taking disciplinary action against him. Then the next.
There is no dispute, Mr. Kiangami. There is no dispute on what you are reading. The only question is whether actually this law, this decision has laid down periodical review of suspension. That is the issue. I think you are trying to drag this, you are trying to drag that, pull this, that, but this court is not satisfied. Because all this which you are reading, this Khemchand's case, also speaks about suspension of the government servant pending an inquiry is a necessary part of procedure for taking disciplinary action against him. There is no doubt on that. There is no doubt on that. There is no doubt on that. Only thing is actually like Ajay Kumar's case. It has decided that periodical review of suspension, which is 3 months. And if the suspension is not reviewed, even within this 3 months, then the suspension is bad. That is what this Ajay Kumar's case is decided. Yes, what is your next para?
Next para is the article case. Yeah, I don't really read it. And the last, the paragraph 24 is
22, paragraph 24.
22, 23, 23 is
Para 23,
24.
para 24.
Here, talk about the relevant part. It is admittedly in Ajay Kumar Chaudhary Supra, the 2 judges bench did not consider the earlier Constitution bench judgment on the issue of suspension. While the binding precedent of the law laid down by a larger strength, the Constitution bench of the Apex Court in Central Board of Gauhati, Community versus State of Maharashtra held as under. Having carefully considered the submission made by the learned senior counsel for the parties and having examined.
I am not getting where you're reading. Having carefully, okay, having carefully. Read.
Having carefully considered the submission made by the learned senior counsel for the parties and having examined the law laid down by the Constitution bench in the above decisions, we would like to sum up the legal position in the following term. Next paragraph, the law laid down by this court in the decision delivered by a larger bench, a bench of larger strength is binding on any subsequent bench of lesser or co-equal strength. That will suffice. Here, yes, what I'm trying to say is, though is my submission is not convincing this court, but what I'm trying to say is,
No, you're convincing.
I'm trying to say that Ajay Kumar case has not relied on the judgment in the Ken Chang and RP Kapoor case.
Mr.
Yes,
This thing.
I'm just summing up my conclusion.
No. I would have appreciated. I would have appreciated your submission if you had actually brought these judgments before this court, and you had satisfied this court that in this case, the Supreme Court had earlier discussed about the periodical review of suspension of a government. That is the issue. See, that is the issue. If you could have actually satisfied this court, then of course this court may have referred the case to the larger bench. But I don't know.
My submission is that not discussed in detail, but a blanket that it must be suspended during the period. That is the whole review, critical review, my lord. I've made understood clearly, but what I'm trying to say is I need to defend the case. So that is my case, Lordship. Lordship. And besides, the last one, last paragraph.
Last one is more against you.
No, Lordship.
21.
No, 22.
22.
Yes.
Okay.
So far as the fact of the present case are concerned, the appellant has now been served with a charge sheet, same as ours, Lordship. And therefore, this direction may not be relevant to him any longer. The direction in paragraph 21, Lordship. However, if the appellant is advised so, he may challenge the continued suspension in any manner known to law. And this action of the respondent will be subject to the judicial review. So, Ajay Kumar case itself does not suspend, interfere with the suspension order, Lordship. I pray that this court may not interfere in the orders.
Let us read para 21, Ajay Kumar.
We therefore direct the currency of a suspension order should not extend beyond 3 months if within this period the memorandum of charge sheet is not served on the delinquent officer employee.
So this first part is the suspension order should not be extended if charge sheet is not furnished before 3 months, within the period of 3 months. Then the next. Now in our case, charge sheet is submitted. Then
if the memorandum of charge sheet is served, a reason order must be passed for the extension of the suspension. This part I understood, but what I'm going to say in the 22 is the Honorable Apex Court itself has not interfered with the suspension order. Though kind of opposition may have been laid down.
okay, I have considered your case.
Perfect. And deeply obliged for your patient hearing. That's my humble submission.
Yes, Mr. Ezo. Mr. Ezo, learned counsel for the petitioner. And Mr. Kamani, the learned government advocate for the state respondents. Are the parties in the line? There's an order.
For hearing, item number 45.
Tackle this. What is the matter, madam?
Yes, may it please, Your Lordship. Your Lordship, before I start my submission, Your Lordship, may kindly allow me to place the family tree of Your Lordship. The family tree of
Family
the,
tree.
yes, Your Lordship, the
Babaji.
petitioners as well as the private respondents here, Your Lordship. Because here the dispute is between the two descendants of the family, Your Lordship.
What is the matter? Let us first see. Let us see. So the time will permit. So what is the family tree? Forget. What is the case?
Lordship, here the dispute is between the private respondents and the petitioner, Your Lordship.
Ah.
That are the two descendants, Your Lordship. So,
No, what are the two descendants claiming?
Your Lordship, there's
For
a
or
dispute,
against?
the dispute is with regard to the inherited properties, Your Lordship.
Inherited properties?
Yes, Your Lordship. By the adopted son, Your Lordship.
And how was
And-
this case before this court?
Your Lordship, I may kindly be allowed to place before Your Lordship.
Just
so that-
wait, don't
so that
place
I will
anything.
place, Your Lordship.
First, let me learn your case.
Yes, Your Lordship.
This is a dispute on the inherited properties between the parties.
Yes, Your Lordship.
How this
So-
court is competent? First, you first answer me. How this court is competent to take up this case?
Your Lordship, what has happened is that in 1976, Your Lordship, this issue was already settled in 1976 by the
Okay.
then GP's court, Your Lordship, stating that all the inherited properties belongs to me, Your Lordship. And Your Lordship,
Okay.
since then, that issue, the decision has attained its finality, Your Lordship, since no review or revision of anything has been filed, Your Lordship.
Okay.
But what has happened is that after almost 45 years of peaceful ownership and possession, Your Lordship, the private respondents, they are suddenly coming and claiming all the inherited properties, Your Lordship. So that is the main issue, Your Lordship.
1967.
1976, Your Lordship.
1976, the GB's court
Yes,
or DB's court.
GB's court, Your Lordship.
GB's court.
Yes, sir.
That means the village council.
Yes, yes, yes.
Village council or GB's court? I don't find anything as GB's court.
Your Lordship, that was, Your Lordship, even the decision was reflected in the judgment of the Kifir Village Council, Your Lordship. So,
Let me see your prayer. All these disputed questions of facts, it may not be, this court may not be competent.
Your Lordship, it is my humble submission that the petitioner is not here to decide the title of the property. There is no dispute with regard to that, Your Lordship.
Okay.
It is only for the private respondents to comply with the decision that was passed by the Davis Court, Your Lordship.
And who is respondent number 4 to 7?
Your Lordship, they are the ones who are claiming all my inherited properties, Your Lordship.
Are you coming prepared with constructive res judicata?
Yes, Your Lordship.
Do you have citations?
Yes, Your Lordship, I have citations.
Yes. For so and so, so and so. Why the state government is a necessary party? Why
Your
your
Lordship.
state government is a necessary party in this case?
Your Lordship, but because in this, in my prayer number 1, Your Lordship, I'm praying for direction to the state respondents to give me protection, Your Lordship.
Protection
And
of order.
yes, Your Lordship, and this honorable court has, by order dated 18/11/2022, Your Lordship, has given a direction to the state respondents to give me protection, Your Lordship.
Protection against their encroachment?
Yes, Your Lordship,
Or what?
because the petitioner has been constantly harassed by the private respondents, Your Lordship, which is why, Your Lordship, I am praying for this, for intervention of this.
Let
honorable
us
court.
see that Kipiri's decision. That GB's decision, let us see, 76 or something.
Your Lordship, that was the oral judgment, Your Lordship. However, the judgment was reflected in Your Lordship and the decision that was passed by the Kifiri Village Council.
Let us see.
And Your Lordship may kindly come to page number 67, annexure number 6, Your Lordship, the decision that was passed by the Kifiri Village Council. Your Lordship, the translated copy of the decision is in page number 70, Your Lordship, translated copy.
Page number?
Page number 70 is the translated copy.
70.
Yes, Your Lordship. And the operative portion starts from page number 71. Your Lordship, I may read the relevant para, Your Lordship, the operative portion.
Why don't you file a civil suit, making all this as your annexures? Because actually, it will be very difficult for this court. It will be very difficult for this court, and in fact, this court should not have entertained.
Your Lordship, my humble prayer is only for the direction to the state, to the private respondents to comply with the order that was passed by the customary court, Your Lordship.
That is the issue. See, whether this court, without knowing anything about the rightful ownership of the land, whether this court can give that direction.
Because, Your Lordship, the issue is already settled, Your Lordship.
Say, ma'am, did you have any civil practice? That is the issue.
Lordship, because even in the
in this high court, I find that the matters which should have been filed before the civil court is directly coming up here. Many cases we are seeing that. And unless and until the lawyer has a proper practice in the lower court, they will not be able to differentiate what is a writ proceeding, what is a civil proceeding. That is the issue. Without any evidence being led, without any examination, cross-examination of the parties, without making any exhibits, if there is, how can this court just direct the private respondents to actually adhere to the case decided by this village council in the year 2021, and that also basing on an oral order passed by the GB's court?
Yes,
Will it be fair for this court?
Your Lordship, it is my humble prayer that the Kifiri Village Council, after Your Lordship, after hearing all the parties, Your Lordship, they have decided this case, Your Lordship.
No.
So Your Lordship,
You are taking a shortcut to let this court decide the issue and to give a direction to the respondents to adhere to the order passed by Kifiri's court. But this court feels that the question of right, title, and interest on the land is an issue. And therefore, you have to approach the civil court. And if this annexure at page 70 supports you, this has to be made as an annexure before the civil court. And you have to go for your right, title, and interest before a civil court. How can this court just direct the respondents to adhere to this case judgment? It's not possible. It's not possible.
Your Lordship, it is my humble prayer that the customary court, Your Lordship, after hearing all the parties, Your Lordship, they have accordingly decided the case. And in fact, Your Lordship,
You are making the submission just to advance the cause of the petitioner. But this court is making the observation on a broader perspective. If you want this court to give a direction to the respondents to abide by this case judgment, this court is going to reject your petition as a trash, with a direction to the parties to approach the civil. It can't happen. If you're insisting. Yes, if you have a right on the law, why don't you approach the civil court?
Yes, your lordship, actually, as my learned counsel was giving submission, since this dispute is related to ancestral property between the two families. So actually, we wanted to resolve this matter among the families only. We did not wanted to go to any court since it's a family dispute. But in the meantime, while this whole issue was arisen, they are the first one petitioners who had approached this court. My only prayer is that considering the facts and circumstances of the case, and regarding, since this is a joint petition, this is common petition, and the property is in dispute is ancestral property. Petitioner number 2, she is daughter-in-law of the petitioner number 1. Since the main issue here is ancestral property, now how comes the joint petition? Because when you file a joint petition, there has to be a common cause of action, relief, and your grievances. Here, the petition number 2, being the daughter-in-law, how can she claim ancestral property?
And who is the petitioner number 1?
Petition number 1 is the son of the, what they are claiming now, he is the son of the, his father's name, which is this property is in dispute now. So your lordship, that is what I am saying that.
Madam, why can't we refer to the case for mediation?
Your lordship,
In the interest of both the parties, don't stick to this village council. This will not help you in any case.
Your lordship, I'm reliant on the DB's court decision, your lordship. And
Where is that DB's court decision, madam? Don't be stubborn. Where is that DB's court decision?
Lordship, the DB's court decision is in Annexure 49, your lordship, page number 160.
100?
160. Even the DB's court has decided in my favor, your lordship.
This is without jurisdiction. Void ab initio. Without jurisdiction.
Lordship, in all the decisions that was decided, your lordship, the judgment that was passed in 1976 was upheld, your lordship.
What is that 76? Show me. You are coming before a high court, you are making a submission before a high court, and you are just relying on this oral order made by DB's court.
Yes,
How can this court accept your submission?
because the judgment was reflected
Oh
in
my
the
God.
Free Village Council's decision, your lordship. And your lordship here.
We are dismissing your appeal.
Lordship,
And we are
then-
directing the parties to go approach the civil court. Yes, heard Mr.
then,
MS Swanson.
your lordship, you kindly give me some time, your lordship, to do more research on this, your lordship.
No need to research. You have no case. You are actually insisting on this court to rely on a DB's court, on a GB's court judgment, which was passed orally in 1976. And you are coming before this court asking the private respondents to actually abide by the order passed by village council court. And you are coming before this court saying that DB's court has also decided the matter. DB's court has decided the matter without jurisdiction. It's void ab initio. The law is clear. Why are you insisting?
Then your lordship, kindly give me some time, your lordship.
On the prayer of MS Swanson, gonna counsel for the petitioner. Mr. Doctor, 3 weeks. Okay. Yes, Mr.
For hearing,
Yes,
item
Lordship.
number 47.
Lordship,
Yeah.
if your lordship pleases, this matter can be disposed of with a short order
Yeah.
because the parties, my lord, have come to a consensus regarding how to solve the dispute. My lord has heard it on the last day. This is regarding the
The doctors,
junior dental doctors.
during the appointed,
COVID time,
they are
special
challenging.
special recruitment time.
So what is that agreement?
No, lordship, the posts, there were 3 posts created during the COVID. 3 posts only, which was created for the COVID, to meet the COVID exigency. And this time they have advertised, I mean, they are going to fill up 5 posts to the special recruitment drive. So special recruitment drive was made only for the post created during the COVID.
Okay.
So therefore, I'm also agreeing that since they have advertised, so they're trying to fill up 5 posts to the special recruitment drive.
Okay.
But special recruitment drive is, they also agree now that it's only meant for the post created during the
Created during COVID.
So I'm saying,
Correct.
okay, let's the 3 posts go ahead as per the special recruitment drive, as per the impune notification, and the remaining as a one-time measure, and the remaining posts in accordance with the rules.
3 posts which were created during
COVID,
the COVID time.
Let it,
Maybe like recruited through the special recruitment drive.
yes,
And the
Like-
others posts as per the rules.
service rules, all the other
Mr.
posts.
Ncham, are you agreeable?
Lordship, in fact, that's the logic behind Lordship. Lordship, I will not go beyond what the cabinet memorandum says, Lordship, because the cabinet memorandum created only 3 posts.
Yes.
During the COVID. It's admitted fact. 2 resultant vacancies were carried over and advertised during the COVID.
So it is only those posts which were created during COVID by the government.
Special recruitment drive.
Will be by a special recruitment drive.
Yes.
The others will be as per the rules.
Yes.
Are you agreeable to that?
Lordship, in fact, going by the records, Lordship, it's not that my submission, Lordship, it's by the record, Lordship.
You make your submission.
Lordship, may kindly come to Annexure A of my affidavit.
What is that?
This is Cabinet Memorandum dated 25th June 2020. Lordship, at serial number 4.
Mr. Muzui,
Lordship.
why don't you discuss with the department and come tomorrow?
Discuss with the department.
In fact, in a similar case, there 21 posts of Ayush doctors were advertised during the COVID. Actually, the post creation was only 11. 10 were resultant vacancies. Posts created earlier, but that was carried over and made in 21. So in that Ayush case, so Lordship, if I may be allowed to place the order tomorrow. Lordship.
Lordship,
because Lordship, I did not expect this issue.
We have also been contacted, my lord.
No, yes, Mr. Muzuri, you can also produce that order, and then you can also receive at least one line instruction that so far as the post created during COVID will be advertised as per the special recruitment drive. Those beyond the post advertised will be as per the service rules.
Lordship, that second part, beyond the service rule, Lordship.
Yeah.
Now, Lordship, if I may, Lordship, can you give me 2 minutes, Lordship? I'll show you, draw your Lordship attention to the 25th June of this cabinet memorandum at page 12 of my affidavit, Lordship. Creation of 3 posts of junior dental surgeon in community health center. Now, in the same cabinet memorandum, the cabinet has given a direction that all the newly created posts should be filled up by the health and primary welfare department within a month time. So and so. Clause B says department should clearly indicate that this appointment will be temporary. That means all the newly created posts will be temporary in nature, and regular recruitment shall be conducted through special NPSC recruitment drive. So going by the interpretation of clause A and B, Lordship, it clearly stipulates that there are only 3 post creation. Now, Lordship may come to my annexure B again of my affidavit. Number of posts created, junior dental surgeon, 3. It has been notified that only 3 posts were created.
You are impugning the advertisement.
Lordship, yes.
You are impugning the advertisement.
Yes, it's not the advertisement, the notification by which said that 5 posts will be filled up through special recruitment.
That latest notification, 22.
Yes, 22. But Lordship, earlier it was only 3 posts, only those posts created. Now, so they are saying yes, we have to fill up only 3, not 5.
Why don't you get instruction and come? Simple as that.
Lordship, I can do that.
Lordship, I thought you had instruction.
No, Lordship, that I have already discussed with the department.
He has discussed, but at least we need some instruction.
Oh, written instruction.
Yes. Because afterwards you may say that no, that submission was not made before the court.
Lordship, yes. So, Lordship, if the matter can come up on Thursday or
Thursday?
Thursday?
Why don't you send one of your juniors? You have so many
Because
efficient
because
juniors.
the instruction will be on that line only.
Ah,
And in the meantime, I can produce the judgment of the Ayush doctors.
correct.
Even if I'm not there,
Ah,
can I just few, if you worship can take
ah,
notes and then worship has seen annexure A, annexure B, annexure C is relevant of the affidavit.
yeah.
It says only, worship my just annexure C of the affidavit. Paragraph 2 says, this appointment will be temporary, fixed, and regular recruitment according to a special recruitment drive for all posts coming under the agreement. So, and paragraph number 1 says all newly created posts. So those posts only, if you are created by NHA B of the secretary, only 3 posts. And then my notification, the impute notification is annexure 1, which fills up for 5 posts through the special recruitment method. So, my lord, I also agree that the 3 posts, newly created posts, be filled up in accordance with the impute notification, which is annexure 1 of the writ petition.
You file an affidavit, small affidavit. Small affidavit.
What should be the fact?
Okay, stating that the special recruitment drive will be only in respect of those posts created during the COVID pandemic.
Lordship, in fact, in my paragraph 3. Sorry, Lordship. In my paragraph number, yes, paragraph 3 of my affidavit, page 2. They have clearly stated with regard to the interpretation of that cabinet memorandum post creation, the 3, where in specifically, Lordship, I've stated in page 3 in the paragraph, subparagraph, as stated above, more particularly 3 posts of junior dental surgeons were created by the cabinet memorandum 25/6/2020, whereby at clause B, it is specifically mentioned that the department should clearly indicate that this appointment will be temporary and regular appointment shall be conducted through special NPC recruitment drive.
Correct.
Now, this is an affidavit on oath, Lordship.
Huh.
So we are not denying the fact that 2 posts were not there. Because, Lordship, we cannot interpret the cabinet memorandum.
So where is that impute notification?
Lordship, may I come to the petition?
Page 25.
Page
25.
Because the cabinet memorandum has not been overridden, Lordship, by
This is
another
a
cabinet.
junior dental doctor.
Yes, junior dental.
Number of vacancies 5.
5, shown as 5. So actually it's 3.
This is in November 2020.
Yes.
So where is that? Where is that government order creating the post?
Yes, Lordship. That annexure C.
Government affidavit, my lord.
My affidavit.
Government affidavit.
I'm not denying that fact, Lordship.
Government affidavit.
Annexure C. Sorry, annexure B is the post creation. Annexure B is the post creation.
Annexure B.
B, page number 14
This affidavit
of respondent number
signed by Tianu.
Yes, Tanu, yes, additional 6.
Your annexure.
Annexure B, Lordship,
14, my lord.
page 14.
Page 14.
Yes, Lordship. 14 is annexure B. Lordship, may kindly come to serial number 4. Serial number 4, Lordship. Lordship has one. Serial number 4. Junior dental surgeon. 3. So this, Lordship, on record, this is admitted fact.
And where have you stated in your paragraph?
C. Paragraph number 3 at page number 3, paragraph 3.
Page 2.
Page 2, and then relevant portion we'll see in Lordship in paragraph page 3, the subparagraph, Lordship. As stated above, Lordship has found, as stated above, more particularly 3 posts of junior dental surgeon were created by the cabinet memorandum dated 25/6/2020. The annexure A. This is the annexure A, Lordship. This clearly indicates that the recruitment so conducted was temporary in nature till recruitment is done through special regular selection by the NPSC. Accordingly, by notification number so dated 2/7/2020, again annexure B, Lordship. That is annexure B. The newly 3 posts of junior dental surgeons were notified by notification number so dated 5/7/2020. Notified, Lordship, as form, Lordship. Then Annexure C is the guideline frame.
Okay, Mr. Ncham,
Lordship.
you kindly produce the order tomorrow.
Which one?
The order passed by this court in that.
The Ayush, yes, Lordship, I can produce.
And you also like we will record your submission on instructions.
Lordship, yes, definitely.
We will have it tomorrow again.
Lordship.
At your risk. If you don't want to be there, at your risk.
Lordship, I'll leave it to my learned friend.
No, since you are eager to let the post be advertised, this
Yes,
to be
my lord,
advertised.
we
To
want
let
to-
all the persons who are competent.
Yes, to go for the exam.
We want to dispose of, but I don't know. You
Because-
can.
Because the government also agrees that yes. it's
The
only
government has
for-
agreed, so we will take the
Lordship,
time, but.
Lordship, in all fairness, in that Ayush doctor's case also,
Yes.
we have not denied the fact that only 11 posts were created. That has been taken on record by the court, Lordship. I'll produce a judgment tomorrow, Lordship.
Because, yes, Lordship.
Mr. Censor. MT Longjam, learned counsel for the petitioner. And Mr. N. Muzui, the learned counsel for the
Respondent number 2.
respondent number
2 and 3. 2 and 3.
2 and 3. Do you remember the date, the case number?
Lordship. Lordship, if I may give it.
Yes.
Lordship, WPC number 289 of 2022.
WPC number
289
289
of 2022.
2022, order dated
Order dated 27/3/2024.
27/3/2024.
But Lordship, in the judgment, there was a slight typographical error with regard to the date. So that has been changed and that has been corrected by order dated 3/4.
Produce
3/5.
Produce that order. What the orders?
Both the orders. I can produce, Lordship, yes.
3/5.
3/5/2022.
3/5.
Except one date. Yes.
2024. 3/5/2024.
Yes. And I was preferred for correction of the date.
Mr. N. Muzul, the learned counsel for the respondent number 4, shall come with necessary instructions.
2 and 3. Respondent number 2 and 3.
Yes. As well as the order passed by as well as the order dated 27/3/2024 and 3/5/2024 passed by this court in WPC number 289/2022. Listed again tomorrow. That is, what is the date tomorrow?
Tomorrow is 14.
14.
Lordship, may I appear through this?
Oh, yes.
That's possible.
Thank you.
14/5/2024. Yes. You can appear through this.
Lordship. Obligation, Lordship.
Obligation.